The other matter is this one in petition number 4. In his petition, dated 1st November 2017, Honorable David Pkosing, the Member of Parliament for Pokot South, I will hereinafter refer to him as the applicant, seeks 16 declarations. The gravamen of his prayers is that the acts of Raila Amolo Odinga, Stephen Kalonzo Musyoka, Wycliffe Musalia Mudavadi, and Moses Masika Wetangula, together with their political parties, the National Super Alliance, Orange Democratic Movement, Wiper Democratic Movement, Ford Kenya, and Aman National Congress, as well as their supporters, to boycott, sabotage, and frustrate and or obstruct the conduct of the 26th October presidential election, amount to treason and an attempt to establish a government in Kenya other than in accordance with the Constitution. Honorable Pkosing seeks a further declaration that Honorable Uhuru Muigai Kenyatta was lawfully elected in the fresh presidential election held on the 26th October 2017. On 3rd of November, the Deputy Registrar of this court directed that the petition be served upon all the respondents and that the matter be mentioned before him on 15th of November to determine compliance with those directions before a hearing date is fixed. On 12th of November 2017, the Deputy Registrar took the file to the Honorable the Chief Justice and sought guidance in the matter as Mr. Kibe Mungai, Learned Counsel for the applicant, was demanding that this petition should be heard before the 17th of November 2017. Upon perusal of the petition, the Honorable the Chief Justice directed that, and I quote, as the Supreme Court is engaged in hearing time-bound petitions under Article 140 of the Constitution, I direct that this petition be heard by the whole court on priority basis after 13th of December 2017, end of quote. Undeterred, the applicant has returned to this court with an application under Section 24 of the Supreme Court Act and Rule 16 of the Supreme Court Rules, seeking that his petition be consolidated and heard together with this petition. We suppose he is referring to petition numbers 2 and 4 filed by Harun Mwau and Njonjo and another challenging the declaration of Honorable Uhuru Muigai Kenyatta and Honorable William Samoei Ruto, respectively as President and Deputy President-elect. We are this evening going to give directions and commence the hearing of those petitions tomorrow. Honorable Pkosing's application cannot be granted for the simple reason that it does not fall within the purview of Article 140 of the Constitution, which requires petitions challenging the election of the President-elect to be filed within 7 days of the declaration of the results of the presidential election and heard and determined within 14 days of filing. Honorable Pkosing's petition is not seeking to challenge the declaration of Honorable Uhuru Kenyatta as the President-elect. As we have said, Honorable Pkosing's petition is seeking declarations to the effect that the acts of Honorable Raila Odinga, Honorable Kalonzo Musyoka, and their supporters to boycott and attempt to sabotage the conduct of the elections on 26th of October 2017 amounted to treason and an attempt to unconstitutionally establish a government in Kenya. If this court loses focus and succumbs to the pressure and allows all cases by parties aggrieved by the conduct of a presidential election to be heard within the period of 14 days allowed by Article 140, it will be swamped by an avalanche of petitions. It will not be able to determine within that time frame and occasion a constitutional crisis. In the circumstances, we decline to grant this application. We have, as we have stated, Honorable Pkosing's petition is not a time-bound litigation. It will therefore be heard with others after this court determines the petitions challenging the election of the president.